Hello friends, this is Dr. Shashi Agarwal. I welcome you all for the channel Shashi Agarwal Economics and Law classes. Today our subject is business law and the act is Sale of Goods Act 1930 and the topic is very important that is the essentials of the contract of sale. So what are the essential elements of the contract of sale? If you find my video useful, please do like it, share it, and also subscribe my channel Shashi Agarwal Economics and Law Classes. So first of all, we will understand the Sales of Goods Act 1930 is mainly based on the English Sale of Goods Act 1893. Earlier, the sale of goods were covered under the Chapter 7 of Indian Contract Act 1872, but that was not sufficient. So, new Act Sale of Goods had come into force in 1st July 1930, which extend to the whole of India except the state of Jammu and Kashmir. The Sale of Goods Act 1930 deals with the law relating to the sales of goods in India. So Section 4 of the Sales of Goods Act define a contract of sale. Contract of sale of good is a contract where the seller transfer or agree to transfer the property. Property means the ownership of the property, ownership of the goods, the property in the goods to a buyer for a price as a contract of sale. So, contract of sale, the seller transfer or agree to transfer the ownership of goods to the buyer for a price. So, price is the essence of the contract of sale. So, contract of sale, we could say it may be the absolute sale, it may be the agreement to sale that is based on conditions. Now, we will understand. So, contract of sale, it could be sale because if the ownership is transferred to the buyer immediately, then it is the sale. But if the ownership is to be transferred to the buyer in future or some condition, then it is called agreement to sale. Sale, absolute sale, where the property in the goods is immediately transferred from the seller to the buyer, so nothing is left on the part of the seller, then we say the sale has taken place. This is the absolute sale. Counter sale in a shop is a sale or an absolute sale, like we go to DMart and we picked up the things from the shelf and then we offer to the counter boy, then he makes a invoice, we pay the money and gets the goods. So this is an example of the absolute sale. Here the property in the good is immediately transferred to the buyer. But agreement to sell, or we could say the conditional sale, where the transfer of property in the goods will take place in future or on the fulfillment of certain condition, then we say it is an agreement to sell because the ownership is not immediately transferred to the buyer. It will take in future. When A says to B, I will supply you 100 share at the rate of 600 in the month of November 2023. It is an agreement to sale because sale will take place in the month of November. The property in the good shall not be transferred from the seller to the buyer until and unless those conditions have been fulfilled. So how agreement to sale become a sale? The first stage where the seller and buyer they are negotiating, then it is agreement to sale. Seller and buyer agree to sell and buy goods and services at a price, then it is agreement to sale. But if the ownership is transferred immediately to the buyer, then it becomes sale. But if the ownership is to be transferred to the buyer at a future date or some fulfillment of condition, then it is called agreement to sale. X agree with Y on 1st October 2022 that he will sell his car on 15th October 2020 for rupees 1,50,000. So it is an agreement to sale because the ownership will be transferred in the future. So these are the essentials of the contract of sale. It should be a valid contract, there should be two parties, and there should be agreement for the transfer of ownership. And the subject matter of the sale is, so these are the essentials of the contract of sale. It should be a valid contract. There should be two parties. There should be agreement to transfer of ownership. And the subject matter of the contract of sale is good. And the essence of the contract of sale is the price. There should be the goods. They should be sold or they should be transferred to sale on the basis of price. A valid contract means it should have all the essentials of a valid contract. There should be a valid offer, valid acceptance, there should be free consent, valid and lawful consideration, and the party they should be competent to enter into contract. What are the essentials of a valid contract? They should be present in the contract of sale. And there should be two parties. One party should be seller and the other party should be buyer. To constitute a contract of sale, there must be transfer of agreement to transfer the property in the goods seller to the buyer. The party must be competent to enter into contract. There should be minimum two parties because seller cannot sell the things to himself. A club supplied foods and drink to its member at a fixed price. This was held to be not a sale as member of the club pays to the club jointly. Members of a club are undivided joint owners, not the part owners. So there are exceptions where the seller could buy his own goods, where a person's goods are sold in the execution of a decree, then and that during that decree he may himself buy. A part owner can sell his share to the other part owner. Where a pawnee sells the goods which are pledged to him by the pawner, but the pawner has not paid the pawnee has not made the payment, then the pawnee could sell those goods. But in that situation, the pawner may himself buy such goods. A partner may also buy the goods from the firm in which he is a partner, and the basically firm could also buy the goods from a partner. In case there is a sale by auction, the seller may reserve his right that he will make a bid at the auction, and he could also purchase his own goods. And there should be agreement for the transfer of ownership. It's very essential under the contract of sale, the property in the goods, which means the title of the goods, which means the ownership in the goods, that should be transferred from the seller to the buyer. And the subject matter of a contract of sale must be goods. 2 subsection 7 of the Sales of Goods Act has defined the goods. Goods means every kind of movable property. Movable property which could be taken from one place to another, but it does not cover the immovable property. It also does not cover the actionable claim and money. It includes stock, share, growing crops, grass, trees, anything which is forming part of the land, but which could be cut and sold under the contract of sale or agreement to sale is covered under goods. Price. Consideration of transfer must be money paid or promised. It means if the contract of sale is on cash basis, then the cash must be paid immediately, or it may be paid in the future. When there is no money consideration, there is no contract of sale. Like a refrigerator is sold for the exchange of old refrigerator, then it is not a contract of sale. Goods given in exchange for goods or as a remuneration for work or labor is not a sale. Even the existing debt due from the seller to the buyer is sufficient. That is a price, like seller owes to the buyer rupees 2000 and the buyer buys goods worth rupees 2000 from the seller, and that will be utilized for the payment. Then it is a sale. And the price could be paid partly in money and partly in good or some other article of value. A refrigerator company supplies a new fridge of 20,000 in exchange of old fridge and rupees 20,000 in cash. It is sale. Contract of sale could be in writing, could be orally, it could be implied from the conduct of the parties. Making of the contract of sale, how a contract of sale is made. Section 5 lays down the formalities of the contract of sale. First, there should be offer to buy or sell goods for a price. Contract may provide for the immediate delivery of the goods, or it could be the immediate delivery or immediate payment. It could be both. It could be the immediate payment of the price or both. Delivery or payment by installment. That delivery or payment or both shall be postponed. A contract of sale may be made in writing or by word of mouth, partly in writing, partly by word of mouth, may be implied from the contract of the parties. Oral offer may be accepted in the written form. Written offer can be accepted orally. Every contract of sale, there should be two parties. One should be the seller, the other should be buyer. So these could be the conditions under contract of sale. The delivery of the goods shall be made immediately. Delivery may be at some future date. The payment of the price shall be made immediately. The payment of price at some future date. Immediate payment of price as well as delivery. Delivery and payment, they should be done at the same time. Goods may be delivered in due course, but the payment has to be made in installment.